much for that. Okay, so you've got Michael in the house and myself. Michael's from as a director on LightYear Docs, Ven of Optimum, does capital raising through Jam Investments, and you're buying an accounting practice as well. So there's no end in sight.
No.
A very famous Australian hockey player, yes.
Australian Masters player.
Masters, which is good. So it's fantastic. What we're going to do is just go through. So I'll take you through. I don't want to spoil things or preempt things. I just want to do a really nice lead up to where we're going. Obviously, you're pretty well aware that we've always been involved in SMSFs. When I bailed out of Now Infinity, I focused heavily on SMSFs and wrote the Guru's Guide. And now we've made a huge switch to succession, asset protection, and estate planning, which obviously encompasses discretionary trust, bucket companies, SMSFs, etc. So we're doing a lot of work on that at Abbott-Family. I know, Michael, that you're doing a lot of work on this as well. I just want to give a bit of an update on that one. So I know you had some discussions. We've had some very, very preliminary discussions around a potential service that I Love Accounting can offer to particularly financial planners and others who don't really feel comfortable around that. They're comfortable around the succession and asset protection spaces. I'll take them through, but they're just not that comfortable when it comes around to doing wills. But on the other hand, they don't like dealing with lawyers because it's a very expensive process. In fact, just while I'm there, I had a chat with Mike Egan, who's just joined up as a strategist, and he was saying he sent off a couple of his major clients, and they both got bills back from lawyers of 50 grand plus just to do wills and estates, which is fairly typical. It's a long process, but just preempt it while we're here on the potential service that you're offering.
Yeah, thanks, Grant. It's quite interesting because I actually met this morning with a planner / advisor on the Gold Coast for coffee, and they were sort of talking to me. They wanted to ask. They've been looking at the LightYear solutions and everything. Love what we do. Been watching our webinars and part of us, but certainly they've got their own app. So concerned about doing the estate planning strategies. Just don't have the capacity or competence as yet. And they were looking for a solution. And as you said, they've dealt with a number of lawyers who charge like the wounded bull, but also don't necessarily put in place the right solution for their clients because they don't know the client. They don't attempt to know the client by talking to the advisor or the accountant well. And so what I was discussing with them is a solution that we're putting into place as a partner with Abbott-Family and I Love Accounting. It'll probably be under another business division name, but that we will do that estate planning for them, and we'll provide, the simple solution. We'll do the data collection, work very closely with the advisor, and work closely with Abbott-Family so that we're actually partnering with a lawyer, a great lawyer in Grant and Tony, and rolling that out. And so we'll have a number of product prices around that. This particular advisor doesn't want to share fees or be paid a fee back in relation to it, but we'll have solutions in which it's up to you whether you want to mark that service up or pass it on straight to the client. So we've got a question there in relation to that. Doing a simple will on the API. What is the recommended price to charge for this work?
Yeah, so we'll look at that in a couple of weeks and go through. So with the a couple of weeks ago with our Master Strategy Day, which everyone loves. For those of you who are on there, if you haven't watched the videos, they're all available now, plus all the slides. In addition, for those of you who haven't watched it, it's still available. I think it's $199 or $149. You can access all the recordings. You can just do that through our website. But out of that process, Manish Sundarji, who follows us quite a lot, he's very erudite and eloquent young man. He said, look, it's great that all the stuff that you and Michael and Tim are working on at Change GPS, love the strategies, but the issue there is, how do I do it? What's the workflow of the strategies? So in the past, I've gone through the process of doing effectively flow charts. For those of you who've been using our system, I've embedded a lot of the compliance and the flow charts within the system. For example, the moat and the castle, which is typically how I deal with it. But on a day-to-day basis, we deal with so many different strategies and solutions. I mean, from our perspective these days, look, it doesn't matter where you stand in the equation, whether you're an accountant, a planner, mortgage broker, SMSF specialist, lawyer, or succession asset protection estate planning specialist. Essentially, our roles are becoming more challenging. So I'm not talking just about compliance. Obviously, compliance is absolutely crucial, making sure you get the right documents, they're in the right place. You know, you're making the right journal entries, the right accounting entries. But the end of the day is that the amount of fees that we're dealing with. So we're not dealing with $100,000 or $200,000 SMSF. You know, by doing this succession asset protection estate planning, you know, we're starting to deal with quite sizable clients. And for the most part, I would say I certainly know the average price of property up here on the Sunshine Coast, I think, is almost hit the $1 million mark, or probably, you know, 700,000 or whatever. Sure,
Pretty close to it.
Yeah, same probably down on the Gold Coast. Brisbane, Sydney, and Melbourne are already there. So that, you know, if I went back 20 years ago and you're dealing with $1 million client, you just freak out. You know, this is sweaty. Now we're dealing with multi-million dollar clients, or potentially multi-million dollar clients. So the big thing that comes up is that, really, believe it or not, the strategies are the strategies, irrespective of the size of the client. But internally, inside our head, it's like, oh my God, what if I stuff things up or really blow things apart? Which is important that, for example, that all of us make sure that our succession asset protection and estate planning is perfectly in gear. So if you haven't done a moat and castle for yourself, absolutely should be the first thing that you do. So for me, there's a couple of issues here. Is quite often too much analysis leads to paralysis, which is the case. So we don't go there. So the two areas we need to do is, first off, is get confidence in what we're doing, understanding the different structures, how they play out, understand where they track into the laws, etc. And for that, we really need to make sure our training is up to speed. And that effectively we've got, you know, we're really confident what we're doing. We're not at this stage of the equation of being consciously incompetent, which means we're just scared of doing whatever we're doing because we don't really know what we're doing, but we're aware that we might be doing something wrong. To get to that stage of being consciously competent, now, unlike SMSFs, which would probably take you a good year or two to get on top of that, in this space, it's not that difficult. In fact, a lot of it's emotional. Dealing with families, dealing with the ins and outs of people. If you've got those sort of skills, you're well and truly there for that. The second part is, again, going back to managers, is that, well, it's great to have that, but, you know, is there a library there of strategies and solutions and Q&As and client communications that we use? Now, obviously, my good friend Tim at Change GPS has built a lot of good client comms there, which I'd encourage you, if you haven't become a member of Change GPS, do so, because we're working pretty closely in with them. But, you know, from our perspective, is we need to look at both those sorts of equations, getting the confidence, and then have the tools and the systems that break down the workflows. Now, of course, the area that we're working in, and again, you'll see where we are in this space, we're right down at this early adoption phase. So all of you guys, believe it or not, you're what we call the visionaries. So when you have a look at it in terms of the total, unfortunately, the amount of money in the pot looks like this. The visionaries and the enthusiasts, or the innovators and the early adopters, are the ones who make all the money. And then effectively over time, what happens is there's a reduction in the value of the fees you can charge. For example, the protector many of you are doing, if you went back 15 years ago, I think when I had a protector done on me, it was worth $20,000. I think there's someone at the moment, I forget who her name is, but she charges $9,000 to $10,000 for it. most of you are probably charging between, you know, $4,000 to $6,000 to $8,000, depending on the size of it. So the pricing's come down as more and more people are utilising that strategy, but definitely it's worthwhile strategy for you from that perspective. So that if you get down to this end, well, none of you, anyone who's on here is a visionary or an early adopter. So you know, all the people at the back end, just like they'll probably come across this in about 15, 20 years when it'll all be over. So step one, that knowledge level, obviously things like the master strategy day, etc., are really important. But there's two aspects for anything. One is actually working your way through the training. So the master strategy day, you know, you got bits and bobs from Michael going through employee share plans, Tim going through value plan pricing and the tax. You know, I probably went a bit overboard by throwing you in at the right at the very, very deep end, the moat and the castle. And just on that one, for all our strategist members, there were 3 case studies that we didn't really get to in any great extent on the master strategy day. I just simply didn't have the time. But we'll be doing a 2-hour session on Wednesday, starting at 12:30. So it'll be from 12:30 to 2:30. You'll get details on that. And I'll be looking at 2 of those case studies, the first one and also the third one, if you want to go and have a look at your materials you got from the day. So I'll go straight in. We'll look at the solutions for both of those. So it'll be a deep dive on that case study. If you are not a strategist, but you were at the Master Strategy Day, just contact our support at lightyeardocs.com.au, and happy to give you a link to that strategy session as part of it. So it's a good wind up after that event. But again, those Master Strategy Days, these sessions, they're all a little bit of potpourri, you know, that bring together everything. But really what we need to do is get you from that consciously incompetent to consciously competent. So that means you've got to spend some time training, and you really got to do a block. We've built the training standards, or the SEPEPA. If you haven't logged into SEPEPA, go to sepepa.com.au, register your interest in becoming a member. Next week, the board is going through and working out the pricings of memberships and what we'll get for that. So that'll be worthwhile. The second phase is we've set down competency standards, and they're very, very detailed, probably more detailed than competency standards for being an accountant, or for that matter, a lawyer, actually. So we've built some very detailed competency standards. We've gone out to Griffith University, Kaplan. We've also gone to Adelaide University, and who else? There was one other I keep on forgetting. But there was another fairly famous university we went to. Deakin University. And we've offered them to build a course. Now, it may be a little bit early because we haven't got a huge membership yet. Certainly at LightYear Docs or our training area, I Love SMSF, we'll be building a course and hopefully having that up by the end of May. So once you've done their course, it's a 3-day course. I think that's on the 26th, 27th and 28th of May. So if you want to block that out, after that, there'll be a Q&A session or multiple choice. And then you'll become certified, and you'll pay a certification fee to SEPEPA, and then you'll be up and a fully certified SEPEPA advisor. So that'll get you over that confidence, and also give you the bona fides to be a true SEPEPA advisor. So that's the first thing. As I said, it's probably good to get in now while you can, although the standards are very significant. From initial discussions that we've had with the universities, the cost is going to be anywhere between $3,000 to $10,000 to do the course. And we won't charge as much of that, but mainly because we're the first in, but that will effectively be the case. Much the same as if you want to do an SMSF specialisation these days, it's exactly the same. Now, step 2 is, remember we said, okay, we want to become that consciously competent, which you will. But across that broad spectrum, I mean, you can't, when you look at succession, asset protection, estate planning, it's huge. So what we need to do is find a good strategy and solution library that if we've got an issue, that we've got somewhere to find it. Because it's so hard, a lot of us again get frozen. I don't know what I want. I don't know what I don't know. And again, so with Michael and that estate planning solution, for those advisors or accountants who just want somewhere safe, somewhere knowledgeable, and somewhere where it can be quickly turned around, then ILA or the bigger tickets, Abbott-Family can step in and work that out for you if you haven't got the time. If you haven't got the time, then it's incumbent upon you to use, obviously, the LightYear Doc system to build that. Now, the hard thing is that when we deal with a client, it's very easy for me, and it'd be great for you guys to be able to sit and watch me how I pull apart and pull together someone in like 30 or 40 minutes flat. And essentially, I've done it a lot. So I'm now what we call unconsciously competent. So I just know by having a look at a person's structures exactly what I'm going to do and finding out a bit more about their family. So we can sort of get in and get overwhelmed by the whole process. We can outsource where we want, but at the end of the day, we need to go and get our hands dirty. So the problem is, where to start. But like anything, you start at the start. So if you're doing a degustation menu, you don't start with dessert first. You start with obviously the first course and then move on from there. So what we've done, I'm just going to bounce out of here and take you to effectively our system. Now, I know many of you probably aren't using this, and I think it's probably detrimental to your efforts. If I go in here, so you can see here, this is the LightYear Docs homepage. Once I've logged in, as all of you will have, and it doesn't matter whether you're pay-as-you-go or you're a strategist member, you can go to this Strategy and Support Center. So with the Strategy and Support Center, I can search in here. For example, I could do the Protector. And have a look there. So then up comes everything. So I've got the actual document itself. I've got the Protector letter, which you can send out to the clients. I've got the webinar we did on a deep dive on the Protector, the Business Protector, which I love in 2021. And then I've got another one, Asset Protection with the Protector. So a lot of that stuff is the webinar. So we've got a lot around that, which is fantastic. Now, the problem about that is when I have a look at, so I'm going to go down on death. It's all very well to have a lot of webinars, but we don't have, if you're not there, I mean, you might spend some time watching it thereafter, but it doesn't really get to the end point quickly. So you can see here, I've just put in death, and it's going to take me to this section here. So I'll just go there. So saving tax on death benefits. So to show you where I got there, I'm back at LightYear Docs. So this is on our support center. You can see all those webinar videos. As with this video, it will be available very shortly this afternoon. Legal, technical, and strategy questions. So what happens is we get a lot of questions that are sitting on our support tickets. So this is our back-end support center. This is what we're famous for, is our support. You can see there's a lot of questions that have come in that are now being fixed up. So our developer, Manuel Bass, is our head developer. So his team will work on that. You can see there I've got a lot of stuff sitting in there as well that needs to be sorted out. So that essentially is our support center. Now, what will happen there is that I will go into that support center and I'll find a couple of things. I'll find a question. So someone's asked me, is there a stamp duty on transfer of property from a self-managed super fund in South Australia? So I found out that there's not. There's a beneficiary exemption. So there's a little article there that talks about that from a technical perspective. So we've got technical solutions there. Again, when do you use a member-directed investment strategy? So we talk about that. So these are the questions that come to me. And again, so it's building up a library for yourselves and also for our support team. But again, Manage sort of got me thinking. So I decided to go a bit further. So again, you've got all your client emails, data capture. This is the one that's a new one. So this is a client strategy, it's an advisor client strategy and solutions center for your how-to solutions. You will find a wide range of client strategy and solutions used by accountants and financial planners. Now, I haven't gone to any great extent. You can see this is very rudimentary, so we've only just built the system, but I expect to put on one or two per week. If there's ones that you would specifically like to go up, how-tos, just put them up on the support center. To get that on the support ticket, we have to do just the support and then essentially do your how-to there. So for example, this is I'm going to go through both of them just to give you an idea. So this is my fun one. This is the one I love, saving tax on death benefits. Most of you are pretty well aware that in Australia, we have taxation of basically death duties on superannuation death benefits compared to assets sitting outside. So superannuation can be quite problematical when it comes around to estate planning. And it doesn't matter whether it goes to the estate or, our preference is obviously to pay it out quite directly. So in terms of taxable components that are paid out to, for example, adult children, there's going to be 17% tax on them. So if we just go through, so the problem here is we're a member of a superannuation fund, and we're not talking about SMSF, we're talking about retail industry or SMSF dies. Any taxable component will be taxed in the hands of non-dependents at a rate of 17%. This is a death tax and not liked by clients, obviously, but many of your clients probably aren't aware of it. And we don't really push it to our clients because we don't have a solution. And mind you, if we've got a solution, then you're going to push it to as many clients as is possible. So the background, if the beneficiary of the deceased member's super death benefits is death benefits dependents, for taxation purposes, then there is no taxation on the death benefit, section 302-60 of the Tax Act. So we've got the problem, we're now going into the law, and the law gives us confidence because if we've seen the law, then we know what the law is. You can't make up the law. There's no fake news when it comes around to the law. The law is the law. So section 302-195, a death benefit dependent of a person who has died is the deceased person's spouse or former spouse. Now, if you're a death benefit dependent, then as I said up here, it's tax-free. Deceased person's child aged less than 18 or any other person with whom the deceased person has an interdependency relationship under section 302-200. So you can go through and have a look at that. And there's an ATO ruling on that, but that's essentially if you're caring for each other. And D, and again, this is enshrined in the legislation, any other person who is a dependent of the deceased person just before he or she died. Now, in relation to that, the ATO's ruled that financial dependency is included, which is in D, with no taxation. So subsection D enables a person who's a financial dependent at law to be treated as a financial dependent. In the Commissioner's private binding ruling, and I've given you the reference there, and you'll also find that that's available as an attachment in this series as well, ruled that there was no death benefits tax in the following case. The beneficiaries did not reside with the deceased. It was actually their father who'd been separated from the mother and they lived with their mother. Rather, beneficiaries lived with their parent. The beneficiaries did not receive any financial support from their parent. So that's their mother. The deceased, who's the father, provided the beneficiaries ongoing financial support, including the following: regular payment of tertiary education course fees for the first beneficiary. Now, remember, these people are over age 18, so we can't be in that B, we have to fall into D, and we can't go into C because they're not interdependent because they're not living with each other. The second one is a provision of supplementary income to the secondary beneficiary for living expenses. That's crucial. And the third one, a provision of supplementary income to the third beneficiary for living expenses. Now, the Commissioner says the facts indicate the beneficiaries were financially dependent on the deceased at the time of the deceased's death. The beneficiaries were reliant on the regular, continuous contribution of the deceased to maintain the standard of living to which they were accustomed. Consequently, the beneficiaries are death benefit dependents, the dependent of deceased for the purposes of section 302-195. And so any payment to those children would obviously be tax-free, either directly from the super fund or if it was passed over to the estate. Okay, so we've gone through the problem, we've looked at the legal side, we've looked at an ATO ruling. Now let's have a look at the advisor's solution. As the Commission has ruled, financial dependency is established under the Tax Act, where a person provides a better standard of living to another person on a regular and continuous basis. As advisors are aware, many parents provide for their adult children and the adult child's family on an ad hoc basis. Now, we're getting to the nub. The Family Allowance Agreement formalises a relationship between the parties, and that's by way of a contract, which may substantiate and evidence the matter of financial dependency. So it doesn't matter whether it's our system works for SMSFs, retail and industry funds. The Family Allowance Agreement is a monthly or quarterly payment made by a member of a superannuation fund, made by a parent to a member of a superannuation fund. It applies to retail, industry, SMSF, to a specific person, or better still, a family, so the entire family has some of the living expenses met. So, quick example, John and Sally Smith, aged 60, provide a $700 per month family allowance to their son, Max's family. This is directed for living expenses of Max, his spouse Anne, and two sons, William and Harry. This is under a formal and binding family allowance agreement. So how to create the family allowance strategy. So if a client's in a retail or industry super fund, first off is to identify who is to be a financial dependent. So that includes maybe not just, so you could do one just for Max, but why do it for Max? Because if you're giving it as a family allowance, it covers the whole of the family. Ensure the client has a binding death benefit nomination directing the member's death benefits to family members identified. That's absolutely crucial. Otherwise, it's going to be up to the discretion of the trustees of the retail industry fund, which you don't want. 3, complete a family allowance agreement, which can cover a couple and any child or family, such as brothers and sisters. And then it's just a matter of clicking on that, and that will take you, for example, straight to the family allowance agreement. I don't know, what did I do with it? It's around here somewhere. Okay, so now the second one, if the client's an SMSF, then upgrade the client deed to a strategic SMSF deed enabling the family allowance. So that's step 1. So you've got that, you just click that and complete that. Step 2, complete a family allowance agreement, much the same as before that. And second one, provide a dependency declaration by the member of the fund detailing each financial dependent. So that's actually available on the site, which I haven't put in there. So I'll fix that up very shortly. So we've got a dependency declaration there as well. So that's our system. So for retail fund, essentially you need to complete one document. And what will happen there is on the death of the member, you'll then approach the trustees of the fund, show them that they are members, so they don't take any PA, so they're financially dependent, so they don't take out any PAYG. If it's an SMSF, we go through the same process, but we want to upgrade the deed, we want to do the family allowance, and then the dependence declaration, which is on our site, and I'll put that in there. So a lot of it's going to depend, when we come around to the recommended pricing, a lot of this is more akin to Tim's value plan pricing. For example, if the client's got $1 million of taxable contributions and they've only got adult children left, which is generally always going to be the case because it'll go from one to another. At some point in time, it's going to land in the adult children's hands. Then effectively what we've got there is a potential tax bill of $170,000, which is quite sizable. So I would say there that if you're building this for a client, that a fee of around about $7,500 is justifiable, particularly for an SMSF. You're upgrading the deed, you're doing a family allowance agreement, and then also you're doing dependent declarations as well. So that sort of goes from the whole gamut of that strategy, saving tax on the death of a family, goes through the workflows, charge out rates, etc. So what do you think about that one, Michael?
I think it's fantastic.
Yeah, look, I think
I agree with the price too.
Yeah, so I think it's a pretty good idea. Backhouse actually just said probably, I'll show you the next one we can do, but the pricing is probably right. So again, I'd encourage you, if you do want any particular issue broken down from a strategy perspective so that you can see, one, what the issue is that you're going to tell me. I'll go through the background, the law, look for ATO rulings, we'll look at the solutions, we'll then do the workflows, the document flow, and also the recommended pricing. So the other one I did today, so all I'm going to do is just go back in there. I did one, and this is one that's probably pretty important for all of us. So when we have a look at it,
we get a lot of questions around this too, don't we, on the support desk?
Absolutely. Yeah. So we get at least one or two questions a day, which the problem is about that is that either Michael or I have to answer it, whereas now our support team watching this, so they'll be able to direct people to it. So again, what's the problem? Over time, a client's family circumstances change, including death, divorce, dementia, and bankruptcy. That's pretty obvious. This means that the family discretionary trust will also undergo changes, including the change of the appointor to the trust, the trustee, might even be a name change after divorce, or the deletion or addition of beneficiaries. So the big danger, and I saw this recently, and I would say, I was just having a chat with Tim Munro, and let me just go through this case, and I'll put this, and I'd like to emphasise it because I would estimate that at least 70% of discretionary trust deeds set up in Australia are defective. Now, let me go through and what happened in this case. So Tony came to me and said, look, I've got a client overseas. He set up a trust for his wife and bloodline, everything okay, and that just wasn't a Abbott-Family deed because this wouldn't have happened. It was another competitor's deed. Client went over to South Africa, unfortunately, I think caught COVID and died. He said, look, what I want to do is make the spouse, obviously the appointor and the trustee, or put in place a corporate trustee, which seems right. And remember, all the benefits were going to the spouse. Now, the problem about that is that I went in and did a deep dive on the deed. Now, the only trustee for that trust and the only appointor for that trust was the individual who died. Now, going into the deed itself and reviewing the deed itself, so I started off, the first thing you always start off is the appointor. And unfortunately, the only person who could appoint a new appointor was the old appointor, the current appointor who deceased. So that means that in that deed, effectively, you can't really put in an appointor. Now, you'd be able to upgrade the deed, for example, to a LightYear docs deed, which potentially allow you to have a different mechanism there, but essentially we're sort of stuffed. Now, the problem about that is then we go to the trustee, and in the trustee, the only person who could appoint the trustee was the appointor, who was also dead. So you've now got a position that there's no trustee, there's no appointor, there's no one in control. So the only way to go forward, and you can see this when you look, and I'm going to talk about resettlement, the Commissioner's guidelines, is you actually have to go to the Supreme Court to adjudicate on this issue and award appointorship and trusteeship to someone else. Now, it may end up being the spouse, but that's going to cost between $30,000 to $50,000. And in the meantime, the spouse, where the monies were left basically for that spouse, effectively is not able to touch $1 of that. So we've got a pretty nasty position. And again, I would say basically how up to date are your clients' discretionary trust deeds. So these are the sort of weaknesses that we need to have a look at and go through all our client discretionary trust deeds and upgrade them, importantly. And then you'll see when we come around, if we need to change appointors, beneficiaries, etc., we can do so at that time. Now, the issue, of course, comes up with resettlement or not. So we need to get this out of the way because there's been a myth that any minor changes, such as a beneficiary, change in vesting date, change in trustee or appointor, may create a new trust or resettlement of an existing trust and thereby result in capital gains tax and stamp duty. And of course, if you've got tax losses in there, you lose the tax losses. The Commission of Taxation has addressed this issue in TD 2012/21, where he stated that despite such changes, that provided there is a continuity of the trust, and that's the important thing, the continuity of the trust, and that came out of a couple of Clark's case and also commercial nominees, then there is no CGT or carry forward of tax loss issues. However, we've noted that any amendment must be in accordance with the trust deed variation or amendment clause, or a new trust may arise. The Commissioner provided a number of examples where the trust continued despite changes to the position of the trust. So example 1, the Acorn Trust is a family discretionary trust that was settled to benefit the members of the Squirrel family. Under the terms of the trustee, a private company of which Mr. and Mrs. Squirrel are directors, has the power as absolute discretion to appoint income to any one or more of the general beneficiaries. The general beneficiary is defined under the terms of the trustee to be Mr. Squirrel, his wife, their children, the grandchildren, and Oak Proprietary Limited, a private company through which the family runs a business of growing flowers to supply local forests. Having decided to get out of the flower industry, the Squirrel family disposed of their interests in Oak Proprietary Limited to an unrelated third party. The trust deed for the Acorn Trust provides for a procedure for the trust to be amended, namely by trustee resolution recorded in writing. Now, again, that's absolutely crucial. Pursuant to this procedure, the trustee resolves in writing to amend the deed to specifically remove Oak, so that's retiring them or removing them by name from the class of general beneficiaries. The trustee further resolves to add the class of general beneficiaries, the respective spouses of the children, trust and companies of which the family has a majority controlling interest, and a philanthropic charity unrelated to the Squirrel family. The making of these resolutions, being a valid exercise power of amendment contained within the deed, does not give rise to the happening of a CGT event, which is crucial. So a simple case study. So I've put in here, the Smith Family Discretionary Trust was established in 2015 with John Smith as the appointer, Johnny's then wife Sally as trustees, and both of them being principal beneficiaries. As part of family law court orders, John must remove Sally as trustee and principal beneficiary, which we see a lot of coming into our support centre. To see how easily this can be done without resettlement, with LightYear docs, watch this short video. So I won't go into it, but
this is Grant Abbott. We're going to look at that.
So you'll see I actually go through what to tick, what to look at, how it applies. So there's a little video there for you. So the advisor solution, so there's two solutions there basically for you. The first one is if you're comfortable with the existing deed that you've got, and more importantly, just make sure you look at the variation. If the trustee client's comfortable with existing deed, then you can use our change in trust positions, which is the document I've essentially done there. There's a little 5-minute video which covers that case study and goes through it. So then if you want to go through that with no resettlement, you just simply go through this process, click on there. Now, instead of using that, you can actually go through a deed upgrade, and that will change all the positions there for you. So you can upgrade to a client deed, to a LightYear Docs Strategic Discretionary Trust, and you can click there. Alternatively, if you're after bloodline solution, then upgrade to a LightYear Docs Leading Member Solution, which focuses on building a succession of leading member appointors, with each leading member appointor being the principal beneficiary, and their children, potentially a spouse of desired grandchildren, bloodline, are also beneficiaries. Now, if you want to upgrade there, you go through that process. So that'll put in that chain of appointors for you. You go back and recast the beneficiaries. The vesting date now extends out to 80 years because we've seen a number of vestings only going like 30 or 40 years. So really, it's a pretty good, strong solution. Now, the recommended fees there, if there's a change in position, the fee should be $750. The deed to be upgraded to a modern trust deed, add an additional $450. But if you're going down to the leading member discretionary trust, I'd put in $1,500 to do that. And again, that's pretty vital. Normally, these come apart. They come as a consequence of family court orders. I mean, if it's family court orders, just understand that the lawyers have fleeced the clients already. So this is not an overly expensive process, but it's something that you'll find all the time. So one is I would say, and I'm going to do another strategy there for you, why you need to upgrade discretionary deeds, and we'll have a letter there to send out to clients for that one. You can see I've got that ATO DT resettlement, which you can download to have a look at. That's a really crucial one. And we'll build that out there again for you, so that we're now starting from our perspective is building a lot more of these strategies and solutions there for you. Again, I would just say you'll see that also our partners such as Michael at ILA and also Tim Munro will also be able to put a lot more stuff up there. So you go to solution is either going into our strategy center, doing a search to see what we've got in there, or alternatively, remember, if we go into our strategy center, you'll have all these blocks here. legal, technical, and strategy questions are just Q&As in terms of specific issues. Webinar videos where we've launched something, or we might have done something in detail, but most of those are around about an hour or so. Client emails, data capture, and letters of advice. So, for example, here you've seen that deed and company trust upgrade. Why go through that? I'll be doing one for discretionary trusts on that one. We've got our estate planning data capture, EPOA data capture, leading member discretionary trust, why that's the case, and then a data capture there as well. So if you haven't done leading members before, you need to have a look at that and then follow it up with the leading member data capture, which is basically an interview style form there that you would do for your clients. So that's essentially where we're going. When we have a look at, thank you very much, John, for all the stuff. We're going to go through a lot more stuff around this one to put up. Have you got any ideas of what you might be putting up there, Michael?
Yeah, I've got a few different ones that I've got. I was sort of running through yesterday when you sent through to me, but I'll put some around some structuring and probably that one I talked about on the Master Strategy Day around utilising when you're doing any entity setups now, putting in that loan and security deed with PPSRs and also the successor director at the same time as you do the structuring. So because it adds value to your proposition, I believe, and also provides solution and risk protection to the client.
Absolutely. So we're really getting back to that stage there is that, none of the solutions we're doing are small solutions. So we're starting to deal with, in this space, that succession, asset protection, estate planning, we're starting to deal with quite sizable clients, so that we need to have that really good, strong workflow that works in, so you've got it down pat, and that's going to make a lot of difference for you, because you can go out there, you've got an idea on the pricing, you talk to the client about the problem solutions. If there's a video or client comms there, then they'll be available, as Michael will do as well. So from our perspective, as I said before, if you haven't been to SEPEPA, I think make sure you jump onto that.
I find the sports centre, even myself, is fantastic, Grant. I'm using it all the time. So it's, and the more we all add to it as a community, the stronger it gets. So.
Yeah, well, the whole idea is that it actually becomes IP for all of us, is that we put stuff up there. And if you want papers, or you've got ideas, or someone else swiping a paper, let us know and we can put it up there, because the whole idea is that it's just an easy place for us all. It's a library for our use. Instead of digging around, the more we can identify in a strategy, these are the key things, the more important it is. So on the SEPEPA site here, I've gone to SEPEPA. You'll see there's this register button comes in, put in your email address, and then that will come back to you. But we're getting more involved. As I said, in the next couple of weeks, we'll be launching our memberships, our foundation, our certified advisors, and then just our associates. The draft competency standards, you can now get those. We're talking with Pricewaterhouse or PwC, who look after all Skills Australia, to get these onto the financial services training package for the Australian government. So we're moving very quickly at that back end. You mightn't see much, but there's a lot going on.
The interest has been very strong too. I think we're pushing 300 now registered interest, which is absolutely fantastic. So more than we probably expected initially.
Yeah, no, it'll be good. So again, as I said, I think it's pretty important. If you've got specific issues, watch out for that accreditation or that certification course. But if you've got specific issues or strategies you want Michael, myself, or someone else to put up, let us know, and then we can break it down. It doesn't take us long, but once it's up there, it gives us all some great guidance. And my goal is by the end of this calendar year to have 100 strategies up there, and really that's really going to cover the gamut of most of the stuff we do. For example, even something so simple as exiting a member from a self-managed super fund, which seems to come to us quite a bit. So we'll go through that process. Anyway, thanks a lot for all your time today. And Michael, thank you for your time. And you've got your partner solution next week. Is there any idea of who the partner is going to be?
No, I'll have to look what we had lined up. So I can't recall off the top of my head right now. Sorry.
Yeah, it'll be good. The other
Yeah.
one that's really important for us, obviously, is weekly webinars. That when we have a look at it, for all of you, we've obviously done this one. This is again that 2-hour session from 12:30 to 2:30 on the 14th of April. We're going through those 2 case studies. You remember them from the Master Strategy Day. So make sure you register for that one. So, because I know a couple of people said, oh, we didn't really get into that case study, but we needed to build that basis first, and then we go and do a deep dive in the case study. So make sure you line up for that as well. Anyway, that's enough from Michael and myself. Thanks, Mick, for making time out of your busy day, and we'll catch you next week.
Thanks.